Well, hello, everyone, and welcome to 10 Tips to Avoid a Grievance and What to Do If You Get One, presented by the Texas Young Lawyers Association. Now, housekeeping matters, this program is approved for 1 hour of CLE credit in Texas. You'll need to self-report your attendance to the State Bar of Texas website using the CLE number that will be provided in the chat at the end of the presentation. I'll put that in the chat with about 5 minutes left to go in that presentation. And feel free to submit your questions through the Q&A chat function during the presentation. And we'll try to get to those either during the presentation or at the very end. Now I want to introduce our speaker. Jay Rudinger is a partner at West Webb Allbritton Gentry, and Jay's practice includes all aspects of civil litigation, including extensive work on grievance matters. In addition to being an attorney, Jay is also a professional wrestler. You may see Jay on weekends around the state of Texas, where he wrestles under the name Drake Durden. And thank you for being here, and I'll let Jay take over from here.
All right, thank you all for giving me the opportunity to come speak with you today and cover a part of my practice that is scary for a lot of people when they first see it come in. But really, once you get a chance to kind of understand the system and understand how it works, shouldn't be something that gives you too much heartburn along the way. I know that Gaines West, who's a shareholder in our firm, was going to do the presentation today, but as we've all learned in the last week or so, there can be travel changes and travel arrangements that go different ways. And he currently is, I believe, sitting on an airplane. I'm not sure how many thousands of feet above the earth, but he is. So I decided I was going to pitch in and take this, but I do a lot of grievance work. I do a lot of work in this area. And really, it's something, like I said, that no one really wants to talk about, but it's something to have a good background in. So here, let me go ahead and screen share for my presentation, and then we can go ahead and get off to the races. So what we'll cover today are 10 tips that you can put into your practice that will help you avoid a potential grievance down the road, as well as at the end, we'll kind of talk about what the grievance process is and what you can expect along the way there if you ever find yourself in that situation. So let me see that slide. There we go. First tip we have is communicate with your client. And I put on there even when it hurts, because it's not all good news that we have to deliver to our clients at times. So we're generally pretty quick to send out a order on a summary judgment we won or something along those lines. But a lot of times we just don't want to send the bad news. And that's when, even when it hurts, that we still have to communicate with our clients. The biggest complaint that the bar sees, and it's not even close to what comes behind it, is lack of communication with counsel. Either not returning phone calls, not responding to emails. And some of it comes from just having something you don't want to tell your client, or, hey, we're all busy. We all have a lot of things going on, and stuff just has a tendency to sometimes fall through the cracks. So that's why communicate with your client even when it hurts. And the other thing I always add is do it as quickly as you can. Bad news is always going to be bad news, but you just need to get it to the client so that y'all can make a decision how to proceed and that y'all can work on the next step. So even when it hurts, make sure that you are communicating with your client. And then also control the way that you communicate with your client. In this day and age, there's all sorts of different mechanisms and ways that people can communicate. For me, I try to keep it to phone and email. I don't want to have WhatsApp chats. I don't want to have anything else. I know there are text message times that I've communicated with folks, but you always want to have a way that you can control the format of what the communication is. And then you also want to make sure you try to have a record of it. So I know some folks know that there's chat. I know, like, for instance, Snapchat that can vanish in a certain amount of time. You want to make sure you have a record. So if you're communicating in a way that's not a written communication, I'd recommend that you develop a habit of following up a phone call with an email or with a text message or something that puts down what you talked about into writing and kind of closes the loop with what you have there. So you have a record of it, the client has a record of it, and you can make sure that you've communicated thoroughly with them. The next part of that tip is don't count on somebody else to do it for you. I know we all have legal assistants or secretaries or paralegals that help us immensely in our practice. But we don't want to get caught and don't want to get trapped in thinking that they're going to be the ones that send the email, or the secretary is going to do it and the paralegal thinks they're doing it. really it all needs to be your responsibility. So make sure you take ownership of your file, ownership of the matter. And if you opened up the matter, if you had the representation with the client, you need to make sure that communication is there and that the client is informed along the way and how their case and how their matter is going. One thing we always have to remember, we have a whole bunch of cases going on, but to that client, that's the most important one that day. So you want to make sure they understand where they are and what they have going. And lastly, it kind of probably goes without saying, is make sure you're truthful in your communications. You don't want to be misleading. You don't want to be trying to hide something. You need to let the client know so they can make an informed decision. As our job as counselors to make sure they have the information to make an informed decision. And the way to do that is be truthful in your communications. All right, tip number 2 is to remember that the ability to practice law is a privilege and not a right. So there's things that we can do that can put that in jeopardy. We're not entitled to the ability to practice law. That bar card comes with a caveat and the ethical rules we have to follow. So just be careful, because what you say, what you do, what you write, all of those things come into play regarding your ability to practice law and to continue to practice law. An example that we have is a few years ago, we had an attorney that had won a big case here in town, and they got a picture at their office, and they had a cigar in one hand and a stack of money in the other hand, sitting leaning back in their desk, taking a picture of, triumphant picture. They had prevailed. And that's great, celebrate your wins. I have no problem with that. But the problem was, sitting on top of their desk were stacks and stacks of case files and client notes. And you could zoom in and you could see who they were representing. You could see pleadings, you could see drafts, you could see notes from different matters. So you always kind of have to think about what you're doing and how you're doing it and what you're presenting. Similarly, we had an example here actually in our office. It wasn't me. I would fess up if it was me, but it wasn't me. And it wasn't Tyler. So it was somebody else. They had had a list of all their matters on a whiteboard. And through the process of handling cases and doing stuff, they had somebody come in and had jokingly written a little or drawn a little cartoon devil head next to one of the cases. And it was because it was somebody they were dealing with, and they had been kind of difficult to deal with. So they had just put it up there in jest. Well, the attorney was in another matter in another meeting, and client showed up for their own meeting, and they were running a little late. So their legal assistant went ahead and showed the client to their office so that they could be there ready for the meeting when they came back. So lo and behold, they're sitting in the office. They look up at the whiteboard with all the lists, including their name, with next to it a cartoon devil drawn on there. Needless to say, there was some explaining that had to be done and some client management that went into that as to what it was and why it was there. But those are just little things that, innocuous as it was when it was done and done in a joking manner, those are things that you have to be careful, because remember, this is not a right to practice law. This is a privilege that we have, and we need to make sure we protect that privilege. Tip number 3 would be, don't talk to anyone that you know or should reasonably know is represented by counsel. And in that instance, that can be a direct violation of our rules. I believe it's Rule 4.02 is contacting someone who's represented by counsel. Now, there are exceptions to that rule, and you can see those in the comments about, for instance, a corporation going down to certain employees that might not have decision-making power. There's certain things that provide exceptions to that rule. You can also get permission to contact someone's client directly, but be very careful. Those, in a lot of these instances, it's better to be safe than sorry is kind of the general rule you should apply in many of these points. And that's one of those. Make sure you evaluate thoroughly and document when you're going to contact someone who you think isn't represented by counsel or something along those lines, because you want to make sure that you're not stepping afoul or crossing any lines or anything like that regarding an ethical rule such as that. Secondly, because I hit it early, is you want to be upfront with your client about not contacting victims. Our clients have a tendency sometimes to want to take matters into their own hands. They think that they can resolve something if the person just would hear them, or if they just had an opportunity to speak with them and they could hear what really was going on. But you and I both know that that's just generally not going to help the situation. It's probably going to make the situation worse. And that's why we should really avoid doing that. One of the things, again, under the better to be safe than sorry category is you don't want to play games. You don't want to be caught trying to have to explain yourself where you were in the gray area, maybe on a rule or in something when you shouldn't even have to get to that point. And that's one of those, having clients contact other opposing parties directly, while not prohibited by any rules, because they're not lawyers, is just something that you shouldn't try to entertain, and you shouldn't, and you certainly shouldn't recommend that your clients undertake. And the last one on this tip is you need to know what to do if someone who is represented by counsel contacts you directly. And as I said, there were exceptions to the rules, and there were opportunities if you got permission. But if this is one of those where out of the blue opposing party contacts you and asks to speak with you, the number one rule is do not communicate with them. If you know they're represented by counsel, you cannot have communication with them. What you need to do is let them know, I can't talk with you. You have a lawyer. You need to speak with your lawyer if you have any concerns or any problems with the matter or have any questions about the case. And then I immediately pick up the phone or open up an email, and I'm sending a message to that opposing counsel to alert them and say, hey, just so you know, Mr. XYZ just called me and he said this about the case, or he had questions about this or anything along those lines, because you don't want to be caught having a story that you contacted them or anything like that. You just want to be forthright. And maybe there's an opportunity there where the lawyers had told the client, you just call this guy, but hadn't let you know. So you can get permission to talk to them directly, and it might help resolve the matter. But the best practice to do at that point is to immediately alert opposing counsel and tell them, hey, your client's trying to contact me regarding this case. I just need you to know that, and either give me permission to talk to them directly, or you probably need to reach out to your client and see what's going on and what you can do to try to make sure they know where they're at and where they're going. Tip number 4 is going to involve the file. And I think we all know the file isn't the lawyer's file. It isn't your office's file. It's the client's file. And you kind of have to know what to do when your client asks for their file back. The best thing to do is, as we all know, and as we understand, the original of the file is what belongs to the client. Not copies, not a copy of the original file. The original file, as you have maintained it, is what belongs to the client. So our recommendation, and the best way to handle that, is you want to make sure you keep a record of what you did and what was done on the matter, to make a duplicate of the file, to make a exact copy for your records, where you had their file and you hand it off, then you get to put the copy in there. One thing to note while you're making that copy is that's not billable time to the client. Because at that point, if they're asking for their file, representation has ended. Those aren't going to be billable hours, but it's necessary for you to make sure to not only keep your records complete, but also to protect yourself. Because if something down the line and they say you didn't tell me about this, or you didn't say anything about that, you want to make sure you have a complete copy of the file at your fingertips so that you can say, yes, we did, and have evidence to show that you did that. Which kind of leads me to the next one of how you need to treat your file. You need to treat it like it really is the client's file, not yours. So you want to make sure all the client documentation's in there, all correspondence with opposing counsel and with the client are in there, and really keep it up to date, and make sure all documents, all pleadings, all correspondence, all anything discovery from the matter are in that file, and that it's up to date. Now we're reaching an age where, if you say read well to some lawyers, they don't understand what that is, because we're all electronic and everything is stored in the cloud, and that's fine. There's not a requirement that you have a paper file for any client or any matter like that. But what you want to make sure is that you're maintaining that electronically, just as you would if you want to say back in the old days when you had a paper file. You want to make sure the pleadings are in there. You want to make sure they're organized properly. You want to make sure that it's easy for them to be able to view. And if a new lawyer gets that file, that they can pick up that file and just take over the representation, or be able to know where they were in the representation and what had gone along during that process. And my last piece of that tip would be to make frequent memos to your file as the representation goes along. And this is something that I don't know if a lot of lawyers do. It was something that early on in my practice, I wasn't in the habit of doing, but I have developed as I've gone along the habit of doing it. And these aren't formal memorandums or a research memo as you would expect in a lot of contexts, but what we have is just a brief note to the file, even if it's an email, even if it's just a handwritten note that you slide into the file if you're going old school with a paper file. But it's just an update on, I spoke with client and we talked about A, B, and C, and here's where we're going next with a date and the time, and then you put that in the file. And that really helps. There's a couple things that it helps. One, it helps keep your file up to date and your communication, as we talked about in tip 1, with your client up to date. But it's also a great way to memorialize phone calls or any conversations you may have had with opposing counsel as well as with your client. And I said it before, it helps you to kind of close the loop. And now you have a record. You're not having to think 6 months down the line, I talked with the client during this 2-month period. I don't remember what I talked about. I don't remember exactly when I talked about it. And, as we're in the setting right now talking about grievances, I'm trying to respond to a grievance and I know I communicated with them, but I have nothing to show for that communication. And rather than having to pull phone records or have to go try to piece back through with time entries or anything like that, it really gives you a quick little way of memorializing what you got. And then you have a whole litany of these memos to the file that you can look back on that shows, 1, communication to the client, 2, the strategy as the case proceeded. And it's a quick read through those and you're back up to speed on where we're at and what we're doing without having to try to search through an email folder or anything along those lines. It's just right at your fingertips there in your file electronically or paper-wise. For tip number 5, this one's primarily, this one here is for primarily litigators. I'm trying to think about things that we'll run into in different settings for getting ready for trial or being down at the courthouse or communication along those lines. One of the big ones are jurors and social media. We get our jury list and we want to do as good a job as we can for our clients and be prepared regarding the jury. One of the best ways to mine any information about a juror is through their social media. You get to see how they live their life in a bunch of different ways and how they might be if they were on a jury regarding any particular claim you may have. So one of the things you'll do is you'll end up getting into social media, but we have to be very, very careful. We can't interact with a juror. One of the biggest things you can't do is, don't send a friend request to a juror. Try to get access to a private profile, like on Facebook or Instagram or anything like that. Don't have somebody in your office send a friend request to a juror or somebody trying to get access to those. You have to stay away from that. You can get to the information you have, but you can't try to surreptitiously get access to a juror's information on social media by doing a friend request or anything like that. And the second thing we need to worry about regarding social media is just what we post and how we post it. Kind of relating back to the story about the picture in the office. When you put that up on Facebook, you have to be aware of what you're putting on Facebook, what the picture shows, and what's in the background, and what you can see, and what information they might be able to derive from that, because it's beyond my capabilities, but there are people out there that can take those pictures, dissect them, blow them up, get all sorts of different information from them if they wanted to. Something that we wouldn't even think would be something that somebody might even consider doing on a picture of me in the office having fun with something. But we just have to think about those things when we post them, and then especially beware of anything we post regarding a trial or anything in a courtroom. We hear stories about posting something about what's going to be used in a trial that next day, a demonstrative, and suddenly it's a question before the judge because it was privileged or confidential information. We've seen it from the judicial side of things, judicial conduct, where a judge posted a picture about anything that what was coming up as a demonstrative, and it was going to be really, really weird, and it was going to be a crazy day in court, and posted a picture before it had happened. And those are things you want to think about before you do that. Again, it seems like it would be fairly innocent enough, but with our ethical requirements of what we have and what we have to keep confidential and protected, you can get past those lines pretty quickly. And I want to remind everybody, if you have any questions along the way, drop them in the Q&A link. I think you can find that pretty quickly on the bottom of your Zoom. We'll try to answer them as we go along, or at the end, we'll circle back if there are any on there that you may have as we go. We'll kind of see as they come in, we'll take them, or we'll pile them up at the end, one way or the other. The other thing we need to watch out about is, and again, what we protect and how we protect it is the information at a courthouse. You need to make sure that your storage arrangements, if in trial with your computer up at on the other side of the bar, or if you're there for a hearing, if you have enough security to protect your files, is the cloud security there on whatever service you're using to make sure no one can access it. If you're using an open internet network, is that safe to be able to use, or are you giving people access to get into your computer and get the information if it's on your hard drive? If you downloaded it to avoid having to use the cloud or access anything like that, but if you're still hooked up to the internet or Wi-Fi, you might open up just your computer to that. One of the other things you got to think about and worry about is just the security of your own client files. Kind of circling back a little bit to what we talked about before. We have handled a matter where a client had a Microsoft OneDrive account and had a file uploaded by a district attorney's office into his OneDrive that Microsoft flagged as having images that they considered to be child pornography because it was from the client's file, and he hadn't seen it, he hadn't done anything, and it was just uploaded because it was on his client's cell phone. Turns out ultimately they weren't. It was improperly flagged. But in the meantime, Microsoft had shut down access to all of his client files, and it took months to rebuild a secondary set of the files using pleadings and getting help from all sorts of different angles because of that. So just one thing you want to think about, not only is your information protected outside of the office when you're in the courthouse or anywhere like that, but just make sure that you're using a program that can protect your information internally. You want to make sure that sometimes you gotta vet who you're using in those instances, and like somebody using a contractor for the house, sometimes the cheapest isn't always the best route. You want to just make sure that you aren't having to answer for why confidentiality was breached or there was a waiver of privilege because someone was able to access your client's files through a program and a server that you chose. Lastly, and this is not litigation specific, this is all lawyers, is be cautious of email strings involving your client. One, if you get further down the string and there's a communication to your client that then involves a third party later on, as we all know, that's going to be waiver of the attorney-client privilege because it has been published to a third party that doesn't protect that privilege. So you just have to be careful as emails start building on each other, if it's a forward or a reply, that you beware of that with clients on it. And then secondly, then you open yourself up to the dreaded reply all. And if a client hits reply all and it goes to not only you, but to opposing counsel or something else, that you suddenly have opened up a bag of worms that you don't want to have to mess with. And the easiest way to do that, and one of my things I do is I try very, very hard to make sure that I don't have my client and opposing counsel on the same correspondence. It avoids any potential crossover. It avoids any potential issues regarding that. But it's something we kind of have to watch out for and monitor as we go. Because what we don't want to do is, again, put ourselves in a position where privileged or confidential information is revealed, not even on our own doing, but if we open that door and make that an option, that's something that then you as a lawyer, because of our ethical rules, have to answer for. Tip number 6 is the old axiom that no good deed goes unpunished. And I know everyone out there, even if you haven't passed the bar, or even if you're still studying in law school, everyone has had somebody come up to them and say, hey, you're a lawyer or you're studying to be a lawyer. I got a question for you. And then they proceed to give you if they're if they want to be cautious, a hypothetical that is within 30 seconds, you know, is definitely about them, or they'll just tell you it's about them, and they have a problem with a cousin who's getting a divorce, or they have an issue with a grandparent that passed away and there's a problem with the probate, or they have a cat in their apartment and the landlord's saying they can't, but they thought that was in the lease. What can you do to help them? And those are always traps and pitfalls that lawyers will fall into. And I don't think we are alone in the profession of people calling them up and asking for help, but we are in a unique position that when people start talking to us and they start communicating with us in anticipation, and that's a very loosely defined term of representation, there's a relationship that is formed between us that with most other professionals, realtors, bankers, anybody like that, it's not going to occur. But for lawyers, any communication in anticipation of representation creates an attorney-client relationship. Now, have they retained you? Probably not, unless your job is to give away free advice. They probably haven't retained you. But retention doesn't mean that's the only way that an attorney-client relationship is created. That's how you solidify and make permanent that relationship. But just because there's been no money or signed contract doesn't mean that you don't have an attorney-client relationship. So you have to watch out for those instances. Like there it says, beware at parties and social gatherings. Those are the times that a lot of that happen. Christmas parties, birthday parties. You know, somebody that finally has the chance to bend your ear about that problem they've been having with their, landscape company that has come in and they didn't do their job, but you paid them $1,500. So what do I do now? So those are all things we have to be careful about. The way I handle it, and some people find it callous and don't like it when I say it, is I always tell them, hey, you know what, it's going to be specific. If it's a lease, I got to see the lease. If it's a probate, I got you. There's more information I need to have. But you can contact my office, and I'd be happy to set up a time, and you can come in and we can sit down and we can talk about it. That way, you avoid having to get too far down the road with them. You have to avoid having to give advice or anything like that, and put yourself out there in a situation that, frankly, you don't know all the facts for yet. And it gives them an opportunity to think that they've been heard, and if they want to really contact you and want to really follow up with some more information, they know where you are and they know how to find you, and they can come back around and find that information. They can come back and meet with you and see if that's something that you really want to help them with, or if they'll just wait until the next party to ask you about it again, which frankly happens more times than you'd like to admit. The second part of this tip is make sure you have a fee contract with your client. Sometimes we're busy, we have somebody come in, we talk to them on the phone, we agree to do a representation, they send us whatever retainer it may be, and we just get off to the races on it. We need to avoid those situations, because really the contract is going to define and determine what we do for them in our representation. It controls not only the scope, which is one of the biggest things you want to do, is because most people aren't getting retained to do everything for everybody. You want to make sure you can define the scope of the representation. It also determines what the billing is going to be, what the retainer is going to be, what the terms of the relationship will be financially, as well as just professionally, what you're going to do for them in the representation. Without a contract, it becomes kind of a he said, she said. Well, they told me they would do this for me and they didn't do this for me. Well, did you do that? No, because that wasn't what I was retained for. How do we know that? We don't. So a contract is a great way to go ahead and kind of tie up all those ends and make sure that we're all on the same page about where we're going and what we're doing for the client. And again, it's communication. It's a great communication tool, because it gives the client understands, and they have the boundary set of what you're going to do to help them. And if they need help on something else, you do a second contract or you amend the contract or something so that you can control that. It's a good way to make sure everybody's on the same page and moving in the same direction. And then lastly on this one, you have to think a lot before you sue your client for unpaid fees. I know we all have run into instances with clients that haven't paid, and you're trying to get an invoice collected, and really, if they don't pay, your only option left really to think about a lawsuit for a breach of contract. And our advice always is consider that very, very carefully, because you have communications that you've revealed to your client that are going to have to come out, and And a lot of stuff's gonna, airing of dirty laundry, because I promise if they haven't paid you, they're not gonna, upon getting a lawsuit, just say sorry and send a check. That rarely happens. But then you also potentially trigger a malpractice claim or a fee forfeiture claim back from them, saying that you didn't do what you were supposed to do, you didn't complete the representation properly, and a bunch of different claims. Now, don't hear me as saying never sue your clients for fees. That's not what I'm saying. But what you want to do is make sure you analyze that and frankly talk to the client about why they haven't paid, or if there's any reasons for why they haven't paid, and maybe there's a solution in there that can be done without involving a lawsuit and without involving having to go to court. But it's just something you have to think long and hard about, because there are some things that come up, such as fee forfeiture, that you open the door by filing that lawsuit for it, a door that might have already been closed or wasn't going to get open in the first place. Next tip, let me grab a drink of water real quick. Involves getting retainers and payments from clients in a flat fee. A lot of times we see this in a criminal setting, where someone will charge a flat fee to handle a criminal matter. And they're in a bunch of different matters. We do some estate planning work that's a flat fee, and various other things. But one of the things you have to be careful for is how you account for those fees and how you address those fees. Because one of the bar's favorite things, if they get a complaint and they find out that checks were maybe not put into the IOLTA account or your trust account as required to be done so by the bar, it's an easy tag on. So for instance, you see it in criminal settings where there will be a primary offense, and then there's some tag-alongs that follow behind it. This is an easy tag-along that a lot of times the bar will find. And it's just, if you can be ahead of the curve and be doing it the right way, it can cut it off at the pass quickly. Is you want to just make sure that any fee you get goes into your IOLTA account until it is properly earned. There are different ways to mark that. If you are an hourly billing firm, then you do that with your invoices. You bill hourly, you send an invoice, and you take that out of that amount and put it into your operating account. Some firms and some lawyers don't operate as an hourly firm. So what you need to do is create a benchmark billing or task billing, and that you set this, and you kind of set it up on your own on the side. This task is 30% of the representation. So once that task is completed, 30% of that funds moves from your trust account into your operating account. And then when you do the next task, it's a 15%. So another 15% comes in from the original amount. So you kind of put yourself benchmarks on the work that you do, so that you know, as it comes in, what work has been done, so that fee has been earned, so that you can move it into your operating account. Because what you don't want to have is the check come in, it goes straight to your operating account on day one, and you're already using that without having done any work on it. That's something that if it comes up later, the bar looks at and they'll frown on, because those fees weren't earned yet. And that's what we have to make sure that we are accounting for in those flat fee retainers. Either do it as a benchmark billing, do it as an hourly billing, or find something that works for you, so that you can break that big chunk up into pieces that, as you do it, as you earn it, kind of like a construction contract would do. As you hit those marks, then the funds get transferred over into your operating account. And then the last one, be wary when accepting something other than money for your services. Chuckles aside, you could have things like art or collector's guns or something like that is used to pay for that. And you just always have to be careful, because when you're not using cold hard cash or anything like that, issues come up about what is it valued at. You have to try to agree with your client that this is a $5,000 gun or whatever it is that you're getting paid with, or what it might be coming in. If you're doing the benchmark billing, then how can you earn 50% of a antique gun? How do you get that if the representation ends early and you haven't completed everything? Do you get to keep the thing, whatever it is that came in? Those are all questions that you can run into. And again, not saying don't do it, but it's something that you have to watch for and be wary of when you get those things in, because we always live in a world where you have the glass half empty. So we try to figure out, what if things go wrong, where are we going to be stuck? And those are things are opportunities where you might get stuck that you really just don't need to encounter unless you absolutely have to. Tip number 8 is be very concerned about confidentiality. And again, even in anticipation of representation, and that's what we kind of talked about at the parties of if I just pick up and I'm chatting with somebody and we're talking about a matter, we've created that attorney-client relationship already. So that's something that needs to be protected. The confidentiality of that as well, all the information you gather from that, frankly, even until something's become public, the representation is confidential. So you have to be careful about public interaction. Seeing a client out and about, you don't want to be the one that goes over to them and says hi unless you're friends with them or in another setting, because you don't want to, if somebody goes, why is that lawyer talking to that guy or that girl, and then suddenly you're stuck having to try to answer questions about that. You have to be careful talking with others and being overheard. So if you're at lunch with a colleague and you're talking about a case, be careful what you say and who you say and how you talk about it, because if somebody at the other table overhears it, they know that person or they know something about the other person they've sued, you're exposing confidential information that you have agreed to keep confidential, and it is your duty to keep confidential. So you just have to be careful how you talk about that. Again, I'm not saying go talk in code and create call signs for all your cases, but just be aware as you're out and about talking about anything you may be doing for work, for your job. It comes up every time people ask, what do you do? What have you been doing at work? And that kind of stuff. You got to be a little bit generic about answering those questions, because you can't be too specific, because you can't reveal that information. And third, you always have to be careful with family, close friends, spouses. You don't keep secrets from your spouse, but there are some things you just can't share. And one of those is the confidential information you get from your clients. So you have to be careful when you go home at the end of the day and your kids or your spouse or somebody says, hey, how was the day? What did you work on? You can't tell them that I was working for this client writing this motion for summary judgment because we're going to get it filed in a week and go win the case. Those are things you have to be careful about, and you have to be wary of. And even representations of friends. If a friend comes in, you can't go home to your spouse that night and say, hey, such and such came in and hired me today to help with X, Y, and Z. It's a mutual friend, but that's not something that you can share, because that's confidential information. So we have to be just careful about all the information we get and how we watch it. Every tip along this way is kind of focused on how we can avoid, falling into a trap of somebody sending in a grievance saying this lawyer was talking about my dirty laundry out and about and somebody heard it, or they got an email sent to opposing counsel that I sent over there because they copied it on an email, or all sorts of different things. We just want to avoid those common pitfalls, or an easily avoided pitfall, to make sure you're not having to try to respond to a grievance about it. And then, as we all know, attorney-client privilege, it's not the attorneys, it's the clients. So we don't get to waive it. We don't get to make any decisions about waiving it. All of that becomes the client's call. Now, in the grievance process, there are certain exceptions. If the client files a grievance against you, communications with that client in response and providing to the bar how things have gone on, or what the relationship was, is allowed, primarily because it's a confidential process. Those won't be published. Those won't make it out into the public. So there's a level of protection with our bar, but then also, like, if you're sued for malpractice, you can do similar things along those lines. Just check what you can and cannot do regarding the waiver of the privilege. But again, as we all know, it's the client's 99% of the time, and it's not ours to be able to share or waive for anybody else. Tip number 9, and we're getting close to the end, is you need to know your responsibilities in a lot of different areas. First responsibility is regarding your assistants and paralegals and secretaries, or whoever you have helping you out. Rule 5.03 says that it is the attorney's job, the managing attorney's job, to make sure that all staff comply with the rules. So, for instance, when I said don't have anybody else send a Facebook friend to a juror on a litigation, that falls back on you because you were in charge of managing that assistant or managing that staff member that did it. Making sure that if somebody from opposing party calls, that the paralegal or the secretary or your legal assistant are not helping them and talking to them and giving them information. You need to make sure they are educated on what they can and cannot do, and if they have any questions, to make sure to talk to you, but then also understand their roles and what they should be doing, and make sure they stay within those. Because again, ultimately, if there's a conduct issue or a grievable ethical violation and it was done by them, it ultimately lands at your feet and your responsibility, because they are your responsibility in day-to-day operations of the law firm. Secondly, you need to know your responsibilities under 1.15 regarding withdrawing from a representation. So looking at 1.15, there's a whole list of things that require you to withdraw. So you need to know what conduct you must withdraw from, conflict of interest along those lines. There's a list of conduct that you can withdraw from, and make sure that those, you've covered all your bases and touch base with the client and make sure that all of those are valid reasons when you go to the court. But ultimately, and the most important thing to remember is, just because you filed a motion to withdraw doesn't mean you no longer represent that party. You are their attorney until you have a court order that says otherwise. So one of the things we see a fair amount is somebody files a motion to withdraw and stops all representation and moves on, basically closes the file and moves to the next matter. And what ends up happening is something gets set and somebody misses a hearing, and now we're involved representing an attorney that thought they had withdrawn but hadn't gotten an order saying so. So now they're having to answer for why they weren't still representing that party and trying to explain their position. So again, bottom line, know when you have to withdraw, know when you can withdraw, but ultimately make sure that you have an order letting you withdraw before you move on, because the biggest issue, the biggest thing the rules want to make sure is that we're mitigating any issues for the client, that they aren't in a bad spot, that they aren't where they are kind of left out to dry. That's not what the court wants to do. So we have to make sure that we're monitoring those situations, monitoring those matters until we get withdrawn, so that we can then end that relationship and that representation. And lastly, a new rule that came in is Rule 5.08, and that's prohibited discrimination. And that's just frankly, a good practice all the time. But it put in that you can't have any bias towards, for really any reason, gender, race, any of them, that for any discrimination in a court proceeding. One thing to note is it doesn't regard representation, but again, you just have to make sure you watch what you do, watch your actions, watch your conduct. Much like we've seen in many times as an innocent comment, or what might seem to be an innocent comment might not be. And now that it's I think long overdue that it was codified in there, but now we have a ethical rule that addresses that, rather than trying to shoehorn it into another rule. Rule 5.08 that prohibits discrimination. And then last tip number 10, I'm going to kind of use also as an opportunity to describe a little bit what the grievance process is, because if you've never had one, it's kind of a weird way it works. It's not like anything else we really do, anything else in the law or in the courtroom or anything like that. And it's good to kind of just get a quick overview of it to see how the process works and where different steps along the way, and what you need to watch for at each step of the way if you end up having a grievance or being involved in a grievance. The new grievance rules were added. I think they started June 1st, 2018, I believe is when they went into effect. There was a sunset review done by the legislature in 2016, 2017, and some new rules were put into place, and some old rules that they had were put back into place, and just kind of revamped the system a little bit. But to give you kind of an overview of the system, and I'll try to not go so fast and use words and try to explain them. So again, look for the question and answer button on your Zoom. If you have any questions as I go through this, or I don't explain something well enough, please put it in there, and we'll double back around to it and answer whatever you may have. But it all starts with a grievance being filed by a complainant, and much like in a criminal manner it's filed, and the state bar and the chief disciplinary counsel look at it, and like a prosecutor, they take it on. It's not, they don't represent the complainant, they represent the state bar. So they will look at it, and really there's three determinations that are made. One, they classify it as a complaint, which means that on the four corners of the document, it states professional misconduct. That's whatever the conduct it says, or whatever was done, or whatever happened could be a violation of one of the ethical rules. If they determine it's a complaint, it will be sent to the responding attorney with a letter, and gives them an opportunity to respond. We'll kind of go back down that path here in a second. The other thing they can do when they first get the grievance in is they can classify it as what they call an inquiry. And that says that it was, a lot of those instances are ones where somebody was upset with the result, but it wasn't a result of unethical conduct, or there was something that made them mad, but it doesn't rise to a violation of any of the rules. They say it's an inquiry and it's dismissed. Now, the party that filed the grievance has an opportunity to appeal that to the Board of Disciplinary Appeals. They have 30 days, I believe it is, to appeal that. But the determination by the Board of Disciplinary Appeals is final. So if they approve the dismissal, the grievance is done. Now, one thing that they added in the new rules at this stage also is a discretionary referral. And what that allows them to do is to send the complaint or the grievance as it comes in. They don't think it raises to a complaint, so it doesn't really state professional misconduct. It's more along the inquiry lines, but maybe there's a way that they can get this solved. A lot of times it might be they haven't heard from their lawyer, or they can't get the file from the lawyer, or something along those lines. That's while not good, it's fairly minor in the grand scope of things. So what they'll do is a discretionary referral is the bar has an opportunity to refer it to the client attorney assistance program, which then brings to the next one. Why should I care about the client attorney assistance program? And what is that? And so CAP, as they call it, is a voluntary and confidential process with where they act kind of as a mediator between the complainant, who's generally a client, and the respondent lawyer. And they will work to try to get anything done, to try to hash out any differences that the two sides might have. So again, regarding, for instance, a file, they'll contact the lawyer and say, can you get a copy of the file? Try to work out for the complainant to get their file, or if they haven't heard where they're at, they'll work to try to get that resolved. And it's a very informal process. Again, one, it's confidential, and two, it's voluntary. So the lawyer doesn't have to participate in it if they don't want to. It's just an opportunity to try to get something resolved quickly and kind of on the front end. And from the records the bar has provided and has stated, it's generally a fairly successful process of getting things resolved and getting the smaller matters at least behind folks. It's got a pretty good success rate of getting that done. So now we've talked about the inquiry that gets dismissed and can be appealed to the Board of Disciplinary Appeals. We talked about the discretionary referral to CAP and getting those resolved. So if they determine it's a complaint, as I talked about in the first part, because it has professional misconduct on the face of the document, they will send notice to the responding attorney, and they have 30 days in which to provide a response. And they'll send the grievance document, and it has their summary of whatever they submitted was the grievable conduct. And then your job as the responding attorney is to provide a written response, a detail of the facts, responding to any allegations they may have. Evidences can be attached, so emails can be attached, contracts can be attached, pleadings can be attached, whatever you need to establish why what you did was not an ethical violation, and why there's no need to move forward with a grievance. So an investigator is assigned by the bar. They work to review with the complainant and review with the responding attorney, review all the information that's submitted. They'll sometimes have follow-up questions, and then they will make a determination on just cause. And the determination of just cause is that they find there is reasonable information or reasonable belief that there's been an ethical violation. So the determination of just cause is made at this point. And so you have one finding is there is no just cause. We reviewed it based on the complaint, based on the response and any additional information. there's no just cause to believe that an ethical violation occurred here. And what it is, they will refer that to the summary disposition panel, which is a grievance panel in whatever region that is, and they review those, and they will recommend dismissal. They will review them and make sure they concur with the investigator based on the information they received. And they will either dismiss it, or they can say, you know, we looked at the same stuff you did. We believe there's just cause, and they can push it into the other bucket. The other determination they can make is they can say, you know, there might be just cause. We just aren't sure. We either don't have all the information, we can't get all the information, or the two stories just don't line up, and we can't really figure out which is the truthful one, which is the right one. What do we have here? So what they can do is refer it to an investigatory hearing, and those were new and put back in the June 1st, 2018 rules. And the investigatory hearing is designed to be an informal hearing process. It's again one of the grievance panels that's in that region. They will convene, and what will happen is they'll just have an informal hearing regarding the claims. Now, what we've encountered and what we've seen in a lot of these investigatory hearings is they can operate in a lot of different ways. Many panels, they'll do everything under oath, so the informal portion of it kind of goes by the wayside quickly. When you're under oath and testifying under oath with testimony that can be used against you at a later point, it kind of, you know, should make the hair on the back of your neck stand up a little bit about what's going to happen in there. And then the problem you encounter is, because it's an informal process, many of the other rules and protections that are afforded when you're usually under oath, either in front of a judge or a jury or another administrative panel, a lot of those are thrown out the window. So there's no issues about hearsay or leading or anything like that might come up that you might be able to use later on to make sure that everything's protected for your client or you as the responding attorney. Those can kind of get thrown out with the wash, but you're still under oath and you're still having to answer questions. So there's a little bit of a juxtaposition there that makes it difficult. What will end up happening after an investigatory hearing is the responding attorney, and if they're represented by counsel, their counsel will leave. Either if it's virtual, they're doing a lot of them virtually right now, via Zoom, just like we're here, or if it's in person, they'll ask the responding attorney and their counsel, if they have one, to leave. And the chief disciplinary counsel or the bar counsel will stay in the room with the panel, and they will kind of discuss the case and discuss what they found, what the information was, if there were any other questions, or if they can provide any other information. And then the investigatory panel will either say that we believe there was just cause, and they will move it along further, and we'll talk kind of what that does. But one of the other things they'll do, and it's in a way to try to resolve these, they'll propose a recommended punishment. One of the things that came from our rules in June of 2018 were kind of punishment guidelines. So sentencing guidelines to a lesser extent of, if this is the kind of conduct, then it's going to be recommending this. And if you do this, then it's this. But if you do this, then it's, so they kind of set forward like we see on the criminal side of things, or even on the, you know, and especially on the federal side of, if you, this is the level of conduct, we're going to punish you here. But if you have an elevated reason for here, then the punishment's up here, or it's a secondary offense. So guidelines for what that may be, and the investigatory panel will submit that to the responding attorney as a potential for settlement, or, hey, this is what we would have done if we were to hear all the evidence and everything. This is the recommendation for punishment. Again, it's a recommendation. It's not what has to be taken. It doesn't have to be accepted, but they'll say just cause was determined, and here's our recommendation. You have 2 weeks if you wish to accept that, otherwise we'll move forward. Moving forward with the just cause determination means going to either an evidentiary hearing if you request to do so, or entering the district court route. The evidentiary hearing side provides confidentiality, but you will be in front of one of those grievance panels. They will hold basically it's a trial on the claims against you and on the merits, and they'll make a determination and findings of fact and a punishment. So much like the investigatory hearing had recommended punishment, this is now after a trial on the merits, and they will make a finding as to what punishment is deserved based on the conduct and the evidence that is before them. Before that, there's discovery that can be done, depositions that can be taken, written discovery. So as you would proceed in a general litigation lawsuit that's available, there's certain rules that like we don't have to do initial disclosures unless requested, and certain tweaks, but it's generally the same process. And there's rules of disciplinary procedure that set forth how all of that goes and any differences, but like rules of evidence apply at the evidentiary hearing. Rules of civil procedure for the most part. There's a few, again, tweaks because of the evidentiary hearing side of things that apply, but you basically get your trial on the merits of your claim. Now, if you go the district court route, it is a filed lawsuit in your area. An administrative judge is assigned to or the administrative judge, or I guess Supreme Court assigns a judge not in that area to hear the case. And it proceeds as any regular trial would, setting a docket control order, initial disclosures, discovery, dispositive motions, the whole 9 yards. The downside to going the district court route is it is public filing. You don't get to seal those. The petition regarding your conduct or the unethical conduct allegations is public and it's out there. So there's nothing that you can do to keep it confidential, as opposed to an evidentiary hearing side. Neither of those, again, are final. You can apply as a district court. You can go up through the process through an appellate court into the Supreme Court of Texas. And on the evidentiary hearing side, you get to appeal up to the Board of Disciplinary Appeals, which acts kind of as the Supreme Court for the bar side of things. So I know that's a giant run, and I know I'm knocking on the door for time. So we got just a couple minutes. Do we have any questions?
Nine. That's the number you want. And
Sure. And if you couldn't, I don't know if y'all can hear the questions are, what, as a young lawyer, do you run into more than a seasoned lawyer would run into? And I really think going back to that first tip of communication, I know as a young lawyer, when I first got started, giving any bad news to anybody was troublesome. I didn't want to do it. So that was always something that comes up. And then communication, we tend to live in a world that we get whatever is at the top of the pile, knock it down, get to the next one, and stuff just keeps floating up. We're juggling a bunch of balls as we go around trying to keep things afloat. So I would say one of the things is make sure that you somehow on your calendar or on a list, you have a case list, and you go through that case list, I'd say once every 2 weeks, 3 weeks if you have to, if you're busy for a week, you got trial or something like that, and make sure you have a touch point each of those with one of those, every case you have during that time. Either an email to the client updating them, even if the update is, hey, I know we haven't talked for a couple of weeks. I just want to let you know nothing's happened. We're still waiting on whatever it is, or they're still supposed to respond to our discovery, or nothing's happening in the case right now. We're waiting to see what the other side wants to do. Just something, because again, like I said, this is to them is the biggest thing they have going. For us, it's a client number or it's a matter number that's in there that we have a bunch of that we're trying to juggle and trying to manage. But for that client, it's the most important thing that they have going on, and we have to treat it like that. So really, I think one of the things I see a lot of young lawyers struggle with is that constant communication. We kind of come from an era, I say we, as the old guy in the room, we come from an era of, no news is good news. For a client, that's not the truth. They want to hear something, even if it is just hey, I don't have anything else to update you on. I know it's been a couple, 3 weeks. And if nothing else, it's a good thing for you to reevaluate those cases and say, hey, you know what, maybe I should be working on getting discovery out so I can tell the client, hey, I'm working on discovery to go out. So, we talked about doing that. We're getting ready to go. Here's the plan, just so you're aware. So really, that's the biggest thing to me, I think, is you get better at managing your time and your schedule and your caseload. That communication starts to become second nature to you a little bit. But early on, you have a tendency to get so tunneled in and focused on certain cases and certain things that some of those others fall off to the side. And like I said, when such a large number of the grievances are communication related. That's really the biggest thing that you can do to make sure you're doing, because even if things aren't going great, if the client feels like they're informed and they're kept up to speed and they know what's happening, it's a totally different relationship you have with the client. In those instances, you know, I'm not going to take any money that's not earned, even if they say it's a tip. You know, that's very generous, but that's something that, you know, I provided services, we agreed to a rate, and we did it. Now, if you want to, you know, make sure you get it in writing, make sure you get something signed by the clients showing that, because again, that's while not unallowed, that's not a word I don't even think, but while it's permitted, you don't want to get, again, 2 months, 3 months down the line, and you receive in the mail the piece of paper that says, hey, such and such said you kept money that was owed to them because something went a little bit south or something went sour. So you want to make sure, you record it and have a record of it, a signed record noted by the client as well. And then once you do that, then you can move that money. Until then, it sits in the retainer or sits in your trust account and is returned to the client unless you get something otherwise showing that that's what they intended to do or want to do with that extra amount.
All right, I think that's all we got for today. Thank you, Jay, for a great presentation. And thank you all for attending this CLE put on by the Texas Young Lawyers Association. And remember to self-report those hours and get that number in. And let's see, look out for any new and upcoming CLEs that TYLA is putting on. All right, thanks.
Thank y'all.